In 2019, an 84-year-old woman in rural Tennessee lost 300 acres of family land in a single afternoon. She did not lose it to a bank. She did not lose it to unpaid taxes. She lost it to a developer named Craig Donovan, a man who had spent years perfecting a system specifically designed to target elderly landowners who were too trusting, too tired, or too confused to fight back. And the worst part, he used her own power of attorney to do it. Eleanor Marsh had owned that land for over 4 decades. She and her late husband had farmed it, maintained it, and passed up every offer that came their way because that land was never for sale. Not at any price. It was the kind of property that stays in a family, the kind that gets handed down, not sold off. But Craig Donovan was not interested in what Eleanor wanted. He was interested in what he could get away with. By the time Eleanor's family realized what had happened, Donovan already had a signed contract. He already had surveyors on the property. He was already drawing up development plans for 300 acres of land he had acquired for less than half its market value. He was certain the deal was done. He was wrong. What Donovan did not account for, what his entire plan completely failed to anticipate, was that the same power of attorney he had manipulated to push that contract through would become the single most damaging piece of evidence against him in court. The legal tool he used as a weapon ended up pointed directly at him. This is not a story about a complicated legal loophole. It is not a story about a technicality. It is a story about an 84-year-old woman whose land was taken from her through deliberate manipulation, and about what happened when the people who loved her decided they were not going to let that stand. By the time this case was over, the contract was voided. The land was returned, and Craig Donovan walked out of that courtroom with nothing except a legal bill and a record that would follow him for the rest of his career. But to understand how that happened, you need to understand how it started. You need to understand Eleanor Marsh, the land she owned, and the moment Craig Donovan made the mistake of thinking she was an easy target. To understand what Craig Donovan took, or tried to take, you first need to understand what 300 acres means to a family that has spent 4 decades building a life on it. It is not a number on a deed. It is not a line item on a property tax statement. It is the place where your children learn to ride bikes on dirt paths that were never meant for bikes. It is the creek where your husband taught your son to fish on a Saturday morning when neither of them had anywhere else to be. It is the tree line you have watched change color every single fall for 40 years, and the particular way the light hits the east pasture on a clear October afternoon that you have never been able to fully describe to anyone who has not seen it themselves. For Eleanor Marsh, that land was all of those things. And it was more. Eleanor was born in 1935 in a small town in rural Tennessee. She grew up in a household that did not have much, but what it had, it held on to. That was the first lesson her parents taught her. You protect what is yours. You do not give it away. You do not let people talk you out of it, and you never sign something you do not fully understand. She married Robert Marsh in 1958. Robert was a farmer's son who had inherited a modest parcel of land from his father and spent the first decade of his marriage figuring out what to do with it. What he did was work. He expanded when he could. He held on when he could not. And by the early 1970s, Robert and Eleanor Marsh were the owners of just over 300 acres of some of the most productive farmland in their county. They raised 3 children on that land. A son, Daniel, who moved to Atlanta in his 20s and built a career in construction. A daughter, Susan, who stayed closer to home, married, and remained the family member Eleanor was closest to as she got older. And a younger son, Michael, who passed away in his 30s, a loss that Eleanor carried quietly for the rest of her life, the way certain kinds of grief never fully leave you. Robert died in 2009 after a short illness. He was 74 years old. Eleanor was 73. And suddenly she was the sole owner of 300 acres, 2 aging farm structures, and a property that required constant attention. Most people assumed she would sell. She did not sell. What Eleanor did instead was manage. She leased portions of the land to neighboring farmers who worked it in exchange for reasonable annual payments. She maintained the timber sections. She kept the fencing in order. She handled the property tax paperwork herself every single year, the same way she had handled it when Robert was alive, carefully, on time, with every document filed correctly. Her attorney at the time later said that Eleanor Marsh was one of the most organized property owners he had ever worked with. She knew exactly what she owned, exactly what it was worth, and exactly what she intended to do with it. She intended to pass it to her children. That had always been the plan. Not a formal written plan, just the kind of understanding that exists in families where certain things go without saying. The land stays in the family. It does not get sold to developers. It does not get carved up into subdivisions. It gets handed down. By 2018, Eleanor was 83 years old. She was still sharp, still independent, still living in the same house she and Robert had shared for decades, the one with the kitchen window that looked out over the east pasture. But she was slowing down in the ways that people slow down at 83. Appointments were harder to keep track of. Paperwork took longer to get through. And there were days when the weight of managing a property that size, even with tenants doing most of the physical work, felt heavier than it used to. Her daughter Susan noticed. So did Susan's husband, Tom. It was Tom who first raised the idea of a power of attorney. He brought it up carefully, the way you bring up things with a woman like Eleanor, not as a suggestion that she was losing her grip on things, but as responsible planning. Something to have in place. Something that would allow a trusted family member to handle paperwork and legal matters on Eleanor's behalf if she ever needed it. Nothing dramatic. Just a safety net, Eleanor agreed. Not enthusiastically, she was not a woman who liked the idea of anyone handling her affairs, but she agreed because she trusted her family and because, practically speaking, it made sense. The family discussed who the POA holder should be. They settled on Richard Haynes, Eleanor's nephew on Robert's side. Richard was in his 50s, local, and had always maintained a close relationship with Eleanor. He helped her with occasional repairs around the property. He checked in on her regularly. He seemed like a natural choice. The paperwork was drawn up. Eleanor signed it in the presence of her attorney. It was meant to protect her. Craig Donovan would find a very different use for it. Craig Donovan did not look like a predator. That was, in many ways, the most important thing about him. He was 51 years old in 2018. Reasonably well-dressed. Soft-spoken in the way that certain kinds of confident men are soft-spoken, not because they lack conviction, but because they have learned that a calm voice gets further than a loud one. He drove a late-model truck, not a flashy car. He attended the same church he had attended for 20 years. He coached youth baseball for a single season in the early 2000s and still mentioned it when it came up. In Harlan County, Craig Donovan was simply a local developer, a familiar face, a man who bought land, built things on it, and sold them. Nothing remarkable, nothing alarming. That was exactly how he wanted it. What the people of Harlan County did not know, what would only surface later during the discovery phase of Eleanor's case, was that Craig Donovan had spent the better part of a decade developing a very specific approach to land acquisition. Not just any land, not commercial properties, not vacant lots on the edge of town. Elderly-owned rural acreage. He had identified, with the kind of cold precision that takes years to develop, that this particular category of property represented an opportunity that most developers overlooked. Elderly owners were often asset-rich and cash-poor. They frequently had complex family situations, adult children spread across different states, inconsistent involvement in the parents' affairs, occasional family tensions that a careful outsider could quietly exploit. They were, in many cases, tired of managing large properties on fixed incomes, tired of paperwork, tired of decisions. And they were, more often than not, too polite to say no directly to someone who seemed friendly and patient and genuinely interested in their well-being. Donovan's approach had 3 phases. He had never written them down, he was not that careless, but the pattern was consistent enough across multiple transactions that his own attorney would later struggle to explain it away in court. Phase 1 was introduction. Low pressure, no numbers, just conversation. He would identify a target property, research the owner, and find a natural way to make contact, a mutual acquaintance. A community event, a casual stop by the property on the pretense of admiring it. The goal of Phase 1 was simple. Become a known face, not a salesman, not a developer, just a neighbor who happened to stop by. Phase 2 was relationship. This was where Donovan invested his time. Regular visits, small gestures, help with a minor repair, a bag of groceries dropped off during bad weather, a birthday remembered. He was building something specific, the sense that he was trustworthy, that he cared, that he was not like other developers who just wanted to flip the land and move on. He made elderly owners feel seen in a way that, if you were lonely and aging and managing a large property by yourself, felt genuinely meaningful. Phase 3 was the offer. And by the time Phase 3 arrived, Donovan had positioned himself so carefully that refusing felt almost rude. He was not a stranger making a cold offer. He was someone they knew, someone they had invited into their home, someone who had, over months of careful cultivation, become something that felt uncomfortably close to a friend. He first approached Eleanor Marsh in the spring of 2018. He had done his research. He knew the property size. He knew Robert had passed. He knew Eleanor was managing the land largely on her own. He knew she had children, but that none of them lived on the property full-time. His introduction was unremarkable. He had heard she owned some land out on Route 9. He was in the area and thought he would stop and introduce himself. No pressure. Just wanted her to know who he was in case she ever wanted to talk about her options. Eleanor was polite. She was also direct. She told him the land was not for sale. Donovan smiled and said he completely understood. He gave her his card. He left without pushing. That was intentional. What came next was Phase 2, and Donovan ran it with the patience of someone who had done this many times before. He stopped by again 6 weeks later, not to talk about the land, but to drop off a bag of peaches from a farm stand he had passed on the way through town. He had remembered, somehow, that Eleanor mentioned she made preserves. He asked about her tenants. He asked how the east pasture was holding up after the wet spring. He visited 4 more times over the following 4 months. He helped her with a fencing issue on the north boundary that her tenant had flagged but not yet fixed. He attended the same community harvest dinner she attended in October and made a point of sitting nearby, talking to the people she knew, becoming part of the same social fabric she moved through. By the end of 2018, Eleanor Marsh considered Craig Donovan a decent man. She was not foolish. She was not naive. She was an 83-year-old woman who had spent a lifetime reading people accurately. She had simply never encountered someone who was this patient, this deliberate, this specifically practiced in the art of becoming trustworthy to people who had every reason to be cautious. And by the time Donovan moved to Phase 3, he had already identified something that would make everything significantly easier. He had found out about the power of attorney. Before we go any further, it is worth taking a moment to explain exactly what a power of attorney is and, more importantly, what it is not. Because one of the reasons Craig Donovan's plan worked as long as it did was that most people, including many of the people closest to Eleanor, did not fully understand the legal instrument they had put in place. They knew what it was supposed to do. They did not know how badly it could be misused in the wrong hands. A power of attorney is a legal document that authorizes one person, called the agent, to act on behalf of another person, called the principal, in legal and financial matters. It is an incredibly common document. Estate planning attorneys recommend it routinely for aging clients. It allows a trusted family member to pay bills, manage bank accounts, handle real estate paperwork, and make certain decisions when the principal is unavailable or unable to do so themselves. Used correctly, it is one of the most practical legal tools available to an aging person and their family. The key word is correctly, because a power of attorney is only as trustworthy as the person holding it. And it comes with an obligation that most people do not think about until it is violated. The agent is legally required to act in the principal's best interest at all times, not their own interest, not the interest of a third party who happens to be offering them something attractive, the principal's interest. Always, when an agent violates that obligation, it is not just a personal betrayal. It is a breach of fiduciary duty, a legal term that carries serious consequences in a courtroom. Richard Haynes either did not fully understand that obligation, or he chose to ignore it. By early 2019, Donovan had confirmed through casual conversation, the kind of careful, indirect questioning he had perfected over years, that Eleanor's nephew Richard held her power of attorney. He did not learn this from Eleanor directly. He learned it the way he learned most useful information. Patiently, indirectly, through the network of familiarity he had spent months building around her. Once he knew, his approach shifted entirely. He stopped focusing on Eleanor. He started focusing on Richard. Richard Haynes was 54 years old. He worked in logistics, managed a modest household, and had 2 kids approaching college age. He was not a wealthy man. He was not a dishonest man, not by his own understanding of himself anyway. He had agreed to hold Eleanor's POA out of genuine family loyalty. He checked on his aunt regularly. He handled the occasional document she needed witnessed or filed. He was also, as Donovan had carefully assessed, a man under financial pressure. Donovan approached Richard in February of 2019, not at Eleanor's property, not anywhere Eleanor's immediate circle would have noticed. He arranged what appeared to be a casual meeting, a coffee at a diner in the next town over, framed as a general conversation about the property and Eleanor's long-term plans. What Richard walked into was not a casual conversation. Donovan had a fully developed proposal. He wanted to purchase the 300 acres for development. He had a number ready significantly below market value, though he presented it in a way that emphasized the total figure rather than the per-acre rate, which made it sound more impressive than it was. He told Richard that Eleanor's land, while valuable, was also a significant liability for an aging woman managing it alone. He talked about maintenance costs, tax obligations, the burden it placed on the family, and then he made Richard an offer that had nothing to do with Eleanor. The details of what Donovan offered Richard would later become a central element of the legal case. What is established in the court record is that Richard stood to receive a direct financial benefit separate from Eleanor's sale proceeds if the transaction moved forward. It was not stated openly as a bribe. It was structured carefully, the way these things always are. But the effect was the same. Richard had a personal financial incentive to make sure Eleanor signed. Over the following weeks, Richard began working on Eleanor. Not aggressively, that would have raised flags immediately with a woman like her. Subtly. He started mentioning the property more in conversation. He raised the idea of simplifying her affairs. He suggested that holding on to 300 acres at her age was more complicated than it needed to be. He framed Donovan's offer as something worth at least considering, a serious offer from a serious local businessman who had treated her with respect. Eleanor was resistant. She said what she had always said. The land was not for sale. But Richard was patient. And he had something Donovan had never had in his previous interactions with Eleanor. He had her trust completely. The kind of trust you only extend to family. The kind that makes you question your own instincts when someone you love tells you that maybe you are being too stubborn. Maybe you are holding on to something out of habit rather than reason. Maybe, at 84, the responsible thing is to think practically about what comes next. Eleanor did not change her mind overnight. It took months of quiet, steady pressure from the one person whose judgment she had never had reason to doubt. And by late summer of 2019, Richard had accomplished what Craig Donovan could never have accomplished alone. He had gotten Eleanor to agree to a meeting. Just a meeting, Richard told her. Just to hear the numbers. No obligation. No pressure. Just information. Eleanor agreed. She did not know that by the time she sat down at that table, the contract was already written. The price was already set, and the man sitting across from her had already decided that her signature, one way or another, was going to be on it before she left that room. The meeting took place on a Thursday afternoon in September of 2019. Richard had arranged it at Eleanor's own kitchen table. That was deliberate. Donovan had suggested it. Not a lawyer's office, not a conference room. Somewhere Eleanor felt comfortable. Somewhere she would be less guarded. Somewhere the familiar surroundings might soften the edges of what was about to happen. Donovan arrived with a folder. Inside it was a purchase agreement that his attorney had spent considerable time preparing. The language was dense. The paragraphs were long. The key figures, the purchase price, the per-acre rate, the closing timeline were not highlighted or summarized anywhere on the first page. They were buried. Not by accident. He also brought a woman named Patrice, introduced as his administrative assistant. Her actual role that afternoon was to manage the pace of the meeting, to keep things moving, to answer questions with reassuring non-answers and redirect attention back to the signature lines whenever the conversation slowed down. Eleanor was at the head of her own table. Richard sat beside her. Donovan opened by thanking Eleanor for her time. He told her how much he respected what she and Robert had built. He said he wanted to be a good steward of the land. He talked about the development plans in vague, pleasant terms: green spaces, responsible construction, a project that would benefit the local community. He made it sound like a legacy continuation rather than a transaction. Eleanor listened. Then she asked about the price. Donovan turned to the contract and pointed to the figure. He read it aloud in a way that emphasized the total dollar amount, a number that sounded significant in isolation. What he did not volunteer, and what no one at that table explained to Eleanor, was what 300 acres of comparable farmland and timber in Harlan County was actually selling for at that time. The contract price was less than 40% of market value. Eleanor looked at the number. She was quiet for a moment. Then she said it seemed low. Donovan was ready for that. He had a response prepared, a careful explanation involving market conditions, the cost of development, the liability of maintaining rural acreage, the tax advantages of a clean sale. It was delivered smoothly, without hesitation, in the calm, reassuring tone of someone who had answered that exact question many times before. Richard backed him up. He told Eleanor that he had looked into it, that the offer was fair given everything involved, that this was a good outcome for the family. Eleanor had another question. She wanted to know if her attorney had reviewed the contract. He had not. Richard had not sent it to him. Donovan had suggested there was no need, that the document was standard, that involving additional attorneys would only slow things down and complicate a straightforward transaction. Richard had agreed. Eleanor asked if she could take the contract home and review it before signing. Patrice spoke up at that point. She explained that Donovan had several other interested buyers, that the offer had a hard expiration, that if Eleanor wanted to secure these terms, the decision needed to be made today. That was not true. There were no other buyers. There was no expiration. It was a pressure tactic, simple, effective, and specifically calibrated for a moment when an 84-year-old woman was already confused by dense legal language and being managed by two people she trusted. Eleanor looked at Richard. Richard told her it was the right decision. She picked up the pen. What happened next involved both Eleanor and Richard signing in multiple places throughout the document. Some sections Eleanor signed directly, others, the sections that carried the heaviest legal weight, the clauses that defined the terms of transfer and waived certain protections Eleanor was legally entitled to, were signed by Richard in his capacity as POA holder. The entire meeting lasted 47 minutes. When it was over, Donovan shook Eleanor's hand. He told her she had made a smart decision. He told her the transition would be smooth and that she would barely notice the process. He picked up his folder, thanked Richard with the particular warmth of a man whose plan had just worked exactly as intended, and walked out of Eleanor Marsh's kitchen with a contract worth 300 acres in his hand. Eleanor sat at her kitchen table after they left. She did not feel relieved. She did not feel like someone who had just made a smart decision. She felt, in a way she could not immediately articulate, that something had gone wrong in that room, that the afternoon had moved too fast, that she had answered questions she did not fully understand with a pen instead of with words. But she was 84 years old. She was tired. And the two people in that room whose judgment she trusted most had told her it was right. So she told herself it was right. She went to bed that night without calling Susan, without calling her attorney, without telling anyone what had happened, because Richard had mentioned casually, at the end of the meeting, that it would be better to let the paperwork process before telling the wider family. Just to keep things simple. Just to avoid unnecessary questions during the transition period. That suggestion, documented later in text messages recovered during discovery, would become one of the most damaging pieces of evidence in the entire case. Because it demonstrated something that no amount of legal language could obscure. Craig Donovan and Richard Haynes did not want Eleanor talking to anyone before that contract was filed. And the reason they did not want her talking to anyone was the same reason Eleanor had felt wrong sitting at her own kitchen table that Thursday afternoon in September. Because what had happened in that room was not a real estate transaction. It was a theft. It had just been carried out with paperwork instead of a weapon. 3 weeks after the signing, Eleanor mentioned it to Susan. Not intentionally. Not as a confession or a concern. It came up the way things come up between a mother and daughter who talk regularly sideways in the middle of a conversation about something else entirely. Susan had called to check in on a Sunday afternoon, and Eleanor had mentioned, almost in passing, that she had signed some paperwork with Richard a few weeks back. Something about the property. Susan asked what kind of paperwork. Eleanor was not sure exactly. A sale agreement, she thought. With that developer Richard had introduced her to. The one who had been stopping by. Susan asked how much. Eleanor told her the number. The line went quiet. Susan had grown up on that land. She had spent enough years watching her parents manage it, negotiate with tenants, and turn down offers to have a general sense of what 300 acres in Harlan County was worth. The number Eleanor gave her was not close. It was not even in the same conversation as close. She asked Eleanor if she still had a copy of the contract. Eleanor found it in a kitchen drawer. Susan drove over that same evening. What Susan and her husband Tom read that night at Eleanor's kitchen table was not a standard real estate contract. It was a document that had been carefully engineered to transfer maximum value away from Eleanor while appearing, on a surface reading, to be a routine transaction. The purchase price was the most obvious problem, 40% of market value, for land that included productive farmland, mature timber, and creek frontage that developers in the region were actively seeking. But the price was not the only problem. Buried in the contract's middle section was a clause waiving Eleanor's right to independent legal review before closing. There was a timeline that compressed the closing window to 30 days, fast enough to limit Eleanor's ability to consult anyone or reconsider. And several of the most consequential sections, the ones that defined the transfer terms and eliminated certain seller protections, had been signed not by Eleanor but by Richard, acting under the power of attorney. Tom read those sections twice. Then he looked at Susan. He said they needed an attorney. First thing in the morning, Susan called Eleanor's longtime attorney, a man named Gerald Purcell, the following Monday. She described what they had found. Purcell asked her to bring the contract in that afternoon. He read it carefully. He did not say much while he was reading. When he finished, he set it down on his desk and told Susan 3 things. First, the contract had serious legal problems. The price alone raised immediate questions about whether Eleanor had received anything close to fair consideration. The waived review clause was aggressive and, depending on the circumstances of signing, potentially unenforceable. Second, and more significantly, the sections signed by Richard under PO authority were deeply problematic. A power of attorney does not grant unlimited authority. It does not allow an agent to conduct transactions that benefit a third party at the principal's expense. It does not allow an agent to waive the principal's legal protections. And it absolutely does not allow an agent to act in a way that conflicts directly with the principal's established and documented wishes, which, in Eleanor's case, had been clearly expressed for years. Richard had not just exceeded his authority. He had inverted it. He had used a document designed to protect Eleanor as a tool to work against her. Third, Purcell told Susan they needed to move quickly. He had seen this before, not this specific situation, but the general shape of it. Developers who operated this way knew that speed was their best protection. The faster the contract closed, the harder it became to unwind. The more time that passed, the more difficult it was to argue that Eleanor had not had opportunity to object. Purcell called the county recorder's office that afternoon to check the filing status of the contract. It had already been submitted for recording. Donovan had filed it within 48 hours of the signing. And when Susan drove past the north boundary of Eleanor's property on her way home that evening, she saw something that made the urgency of their situation immediately, viscerally real. There were surveying stakes in the ground, orange-tipped, evenly spaced, running along the boundary line in a pattern that indicated active pre-development work. A pickup truck with a contractor's logo on the door was parked near the eastern fence line. 2 men with equipment were working along the creek. Donovan was not waiting. He had a signed contract, a filed deed transfer, and crews already on the ground. As far as he was concerned, those 300 acres were already his. Eleanor's objections, if she had any, were a footnote. Richard's signature under POA authority had taken care of the legal exposure. The closing timeline would complete the transfer before anyone could organize a meaningful response. What Donovan had not accounted for was Gerald Purcell. And he had not accounted for Susan Marsh, who was not a woman who drove past surveying stakes on her mother's land and went home and did nothing. That same evening, Susan sat down with Eleanor and walked her through what the contract actually said. Not the version Donovan had described. The actual version. Page by page, number by number. Eleanor listened without interrupting. When Susan finished, Eleanor was quiet for a long moment. Then she asked one question. She asked where Richard was. Susan told her she had been trying to reach him since Monday morning. He had not returned her calls. Eleanor nodded slowly. She looked out the kitchen window at the east pasture, the same view she had looked at every morning for 60 years, Then she told Susan to do whatever needed to be done. Whatever it takes, Eleanor said. That land does not leave this family. Gerald Purcell filed for the emergency injunction on a Tuesday morning. By Tuesday afternoon, a judge had reviewed the filing and granted a temporary restraining order. The surveying crews on Eleanor's property received a call. They packed their equipment into the contractor's truck, pulled the orange stakes from the ground along the eastern fence line, and left. The property was quiet again, but the legal fight was just beginning, and Craig Donovan was not a man who lost gracefully. Within 72 hours of the injunction, Donovan had retained one of the most aggressive real estate litigation firms in the region. Not a local attorney. Not someone who handled routine property disputes out of a two-room office on the county square. A firm with a full litigation department, a support staff, and the specific kind of institutional confidence that comes from knowing your client can afford to make this expensive. Their first move was a counterfiling that challenged the injunction on procedural grounds. It was technically sophisticated, carefully worded, and almost entirely beside the point. But that was the strategy. Bury the other side in paperwork. Make the process expensive. Make it slow. Make Eleanor's family feel the weight of what they were taking on. Purcell did not blink. He filed his response within 48 hours, and in that response he laid out the three legal arguments that would form the backbone of Eleanor's case. The first was undue influence. In Tennessee law, undue influence occurs when someone in a position of trust uses that relationship to pressure another person into a decision they would not have freely made. It does not require threats. What it requires is a pattern. Purcell had the pattern. He had months of deliberate relationship building by Donovan. He had Richard's dual role, POA holder and active advocate for the transaction. He had the meeting itself, the rushed timeline, the false urgency about competing buyers, the instruction that Eleanor could not take the contract home to review. And he had the text message in which Richard told Eleanor it would be better not to discuss the paperwork with the wider family until the transition was complete. That text message alone told a story that no legal language could neutralize. Eleanor had not made a free decision at that kitchen table. She had been walked to a conclusion by two people she trusted. In a room deliberately chosen to lower her guard, on a timeline artificially compressed to prevent her from thinking clearly. That was undue influence, and Purcell could prove it. The second argument was breach of fiduciary duty. Richard Haynes had accepted a binding legal obligation when he became Eleanor's POA holder, the duty to act, at all times, in Eleanor's best interest. What he did was the precise opposite. He signed sections of a contract that transferred Eleanor's property at less than 40% of market value. He signed away legal protections she was entitled to. And he had personally benefited from the transaction, a fact that discovery would later confirm in detail. That was not an agent acting in his principal's interest. That was an agent using the legal authority she had trusted him with to work directly against her. Breach of fiduciary duty carries serious consequences in a civil courtroom. Courts have repeatedly held that contracts executed under such circumstances are voidable, not merely questionable, but voidable entirely. Donovan's team tried several responses. They argued Richard had acted in good faith. They argued Eleanor had been present and had not objected clearly enough. They argued the POA granted broad enough authority to encompass the transaction. Each argument was weaker than the last. The third argument was unconscionability. An unconscionable contract is one so fundamentally one-sided that a court cannot in good conscience enforce it. The standard is high courts do not void contracts simply because one party got a bad deal. But when the disparity is severe enough, and when the circumstances of signing are sufficiently compromised, courts have both the authority and the obligation to act. The contract price was less than 40% of market value. For 300 acres of productive farmland, mature timber, and creek frontage that regional developers were actively competing for. Signed by an 84-year-old woman, given no independent legal review, pressured by manufactured urgency, and told by the person she trusted most that it was the right decision. Purcell had comparable sales, an independent appraisal, and market data. When placed next to that data, the contract told a story so stark that even Donovan's litigation team struggled to frame it as anything approaching fair. What happened during discovery changed the shape of the case entirely. Purcell requested records from Donovan's previous transactions. Donovan's attorneys fought hard to limit the scope. They did not succeed. What surfaced was a pattern. Over the previous 9 years, Donovan had completed 6 similar transactions. All involved elderly rural landowners. All were priced significantly below market value. In 3 of the 6 cases, a family member with POA authority had been involved in facilitating the sale. In 2 of those cases, that family member had received direct payment from Donovan's LLC, structured, as Richard's arrangement had been, in a way that obscured its true nature. Donovan had not done this once. He had done it 7 times, Eleanor included. That discovery did 2 things. It made the undue influence argument significantly more powerful, because Eleanor had not been the victim of an isolated lapse in judgment. She had been targeted by a man who had refined and repeated this exact approach across nearly a decade. And it opened Donovan to legal exposure far beyond the original case. Eleanor gave her deposition in November of 2019. Donovan's legal team had prepared carefully. Their strategy was to establish that Eleanor had been mentally diminished at the time of signing, that her cognitive decline had been significant enough to reframe the entire narrative. Not a predatory developer exploiting an elderly woman. A confused seller who had later changed her mind and was looking for a legal exit. Eleanor walked into that deposition and dismantled the strategy in the first 20 minutes. She remembered the meeting date. She remembered who was present. She remembered the exact figure Donovan had read aloud. She remembered asking whether her attorney had reviewed the documents and the response she received. She remembered the exact words Richard used when he told her it was the right decision. She was precise. She was composed. She was, in Purcell's word, formidable. Donovan's attorneys tried several lines of questioning designed to surface confusion or inconsistency. Eleanor answered each one directly, without hedging, without becoming flustered, without giving them a single usable moment. At one point, one of Donovan's attorneys asked whether she had felt pressured at the signing. Eleanor looked at him for a moment before she answered. She said, "I felt like a woman who was being handled. And I have spent 84 years knowing the difference between being helped and being handled. I knew which one that was." That answer would later be read aloud in court. It did not help Craig Donovan. Richard, meanwhile, faced his own separate legal exposure, a parallel proceeding focused on the breach of fiduciary duty claim, which carried both civil and potential criminal implications. He had retained his own attorney by October. He was no longer returning Eleanor's calls. The 2 men who had sat at Eleanor's kitchen table that Thursday afternoon in September, confident, prepared, certain that the paperwork was done, were now on opposite sides of a courtroom, each trying to make sure the other absorbed the majority of what was coming. The trial was scheduled for the following spring. Craig Donovan was about to find out what happened when the legal tool he had used as a weapon got turned around and pointed directly at him. The trial lasted 4 days. It was not a dramatic 4 days in the way that courtroom scenes are sometimes dramatized. No surprise witnesses, no last-minute evidence, no moments where the gallery erupted and the judge had to call for order. What it was, instead, was methodical. Careful. The kind of legal proceeding where the outcome becomes clearer with each passing hour, not because of any single revelation, but because the weight of the evidence accumulates in one direction and does not stop accumulating. By the end of the second day, Donovan's legal team had shifted from aggressive counterargument to damage control. That shift was visible to everyone in the courtroom. It was visible to Eleanor, who sat beside Purcell each morning, with the same composure she had brought to her deposition, present, attentive, and entirely unbothered by the size of the legal team arrayed against her. The judge issued his ruling on a Friday morning in April of 2020. The contract was voided in full, not modified, not partially enforced with adjusted terms. Voided. Every clause, every signature, every filing that Donovan had pushed through with deliberate speed in the 48 hours following the signing, all of it was unwound. The deed transfer that had been recorded at the county office was declared invalid. The property reverted to Eleanor Marsh, in full, effective immediately. The judge's written ruling was detailed and direct. He did not leave the legal basis open to interpretation. On the question of undue influence, the court found that the circumstances surrounding the signing, the manufactured urgency, the deliberate exclusion of independent legal counsel, the instruction to Eleanor not to discuss the transaction with family, and the months of calculated relationship building that preceded the meeting collectively demonstrated that Eleanor had not entered the contract freely. She had been managed toward a conclusion by individuals whose interests were not aligned with hers. The contract could not stand on that basis alone. On the question of breach of fiduciary duty, the ruling was unambiguous. Richard Haynes had held a legal obligation to Eleanor Marsh. He had used the authority she entrusted to him not to protect her interests, but to advance a transaction that benefited a third party and, by the evidence presented during discovery, benefited himself directly. The POA had been inverted, used as a weapon against the very person it was designed to protect. Any contract signed under those conditions, the judge wrote, cannot be recognized as a valid expression of the principal's intent. On unconscionability, the court found that the purchase price less than 40% of independently appraised market value for property that included productive farmland, mature timber, and actively sought creek frontage represented a disparity so significant that enforcement would constitute a miscarriage of justice. Particularly given the circumstances of the signing, the court found no basis on which to treat the agreed price as a legitimate reflection of fair market negotiation. All three arguments had held. Any one of them, standing alone, would likely have been sufficient. Together, they left Donovan with nothing. The judge also ordered Donovan to pay Eleanor's legal fees. This was not a foregone conclusion. Fee shifting in civil cases requires specific findings, and courts do not award attorneys' fees routinely. But the discovery evidence of Donovan's prior transactions had reframed the case in a way that made the award difficult to avoid. This had not been a single lapse in judgment or a negotiation that went further than it should have. This was a pattern, a deliberate, refined, repeatedly executed pattern of targeting elderly landowners and using their trust against them. The legal fees were substantial. Purcell's team had worked the case for months, through extensive discovery, depositions, and a 4-day trial against a well-resourced litigation firm. The award reflected that reality. Donovan paid. He had no choice. Richard's consequences were handled through a separate proceeding. The civil breach of fiduciary duty finding against him was clear and documented. He faced personal liability for damages related to his role in the transaction, damages that were calculated not as a symbolic figure, but as a concrete reflection of what Eleanor had nearly lost. Beyond the civil exposure, the county district attorney's office had opened a review of the case following the trial, specifically examining whether Richard's arrangement with Donovan met the threshold for criminal charges under Tennessee's elder financial abuse statutes. That review was ongoing as of the time this case became part of the public record. Richard had not spoken publicly. His attorney had issued a brief statement characterizing his actions as a mistake made under financial pressure, without full appreciation of the legal consequences. Eleanor had not responded to that statement. She did not need to. The court had already said everything that needed to be said. Craig Donovan left the courthouse on that Friday morning in April without making a statement. There was no dramatic exit, no visible anger, no confrontation in the hallway. He walked out with his attorneys, got into a car, and left. For a man who had spent years cultivating the image of a quiet, reasonable local businessman, the absence of drama was consistent even here, even in this moment. He maintained the surface. But the surface was all that remained. The verdict would follow him. The discovery record, the 6 prior transactions, the pattern, the documented arrangements with family members holding POA authority, was now part of the public court file. In a county where reputation moves through the same community networks that Donovan had spent years carefully managing, the details of the case spread quickly. Contractors who had worked with him grew cautious. Landowners who had been approached by him in previous years began asking questions. The professional standing he had built over 2 decades began to erode in the way that certain kinds of reputations erode not all at once but steadily, and without recovery. Eleanor heard the ruling from Purcell, who called her as soon as the judge had finished reading. She did not cry. She did not celebrate. Susan, who was sitting beside her at the kitchen table when the call came, later said that her mother listened, said thank you, and then sat quietly for a long moment, looking out the window at the east pasture. Then she asked if they could go to the property. That afternoon, Eleanor Marsh drove to her land for the first time since the signing. She walked the fence line along the north boundary, the same boundary where the surveying stakes had stood for those few days in September. She walked down to the creek. She stood at the edge of the east pasture in the late April light and looked at what was still hers. She did not say much. She did not need to. Eleanor Marsh got her land back. Not every family does. That is the part of this story that is easy to lose in the relief of a just verdict. The fact that what happened to Eleanor is not rare. It is not an outlier. It is not the kind of thing that happens once in a while to unusually vulnerable people in unusually unfortunate circumstances. It happens constantly, in every state, in every county, to elderly men and women who worked their entire lives to build something and trusted the wrong person at the wrong moment. The numbers are stark. According to research on elder financial abuse in the United States, an estimated 1 in 10 Americans over the age of 60 will experience some form of financial exploitation. The total financial loss attributed to elder financial abuse runs into the billions annually, figures that almost certainly undercount the reality because the majority of cases are never reported. The victim is ashamed. The family is reluctant to involve law enforcement against a relative. The process of recovery is exhausting for someone who is already aging and already tired. And in cases involving real property, land, homes, inherited assets, the losses are often permanent. Because by the time the family realizes what has happened, the paperwork is filed, the clock is running, and the developer is already on the ground. Eleanor's case was resolved. Most are not. The power of attorney is where this story starts and where the warning has to start as well. A POA is not a dangerous document. Used correctly, it is one of the most important legal protections an aging person can put in place. But it is only as safe as the person holding it, and the families who create these arrangements often do so without fully understanding what they are handing over. Here is what every family needs to know before a POA is signed. A general or durable power of attorney can grant extremely broad authority. In the wrong hands, that authority can be used to sell property, access accounts, waive legal protections, and make binding financial decisions, all without the principal's direct involvement or knowledge. The principal's wishes, however clearly expressed over a lifetime, are not a legal constraint on an agent who chooses to ignore them. The warning signs of POA abuse are specific and recognizable. An agent who discourages the principal from consulting an attorney. An agent who becomes the primary point of contact between the principal and outside parties, developers, financial advisors, buyers. An agent who instructs the principal not to discuss transactions with other family members. An agent who stands to benefit personally from a transaction they are facilitating on the principal's behalf. Every one of those warning signs was present in Eleanor's case. In plain sight. Visible to anyone who knew what they were looking for. Which is precisely why families need to know what to look for before they need to know it. If you have an elderly parent who owns significant property, there are concrete steps that can be taken right now. Ensure that any POA document contains specific limitations, not just broad authority. Work with an estate planning attorney to define exactly what the agent can and cannot do. A well-drafted POA can prohibit the agent from selling real property without independent legal review. It can require a second family member's consent for transactions above a defined threshold. It can build in protections that make the kind of arrangement Richard and Donovan constructed structurally impossible. Make sure the principal has an independent attorney relationship, someone who is not introduced through the family, who has no connection to any potential buyer or developer, and who the principal can contact directly without going through the POA holder. Eleanor had that relationship with Gerald Purcell. It is the reason her case was recoverable. Keep family communication open and consistent. The instruction not to tell the wider family, the text message that became one of the most damaging pieces of evidence in the case, was only possible because Eleanor's family had not established a routine of transparency around her financial affairs. Regular family conversations about property, finances, and any outside parties who have made contact are not intrusive. They are protective, and if something feels wrong, act immediately. Susan's instinct on that Sunday phone call, the silence after Eleanor said the number, the drive to her mother's house that same evening, is what made everything else possible. The window for legal intervention in these cases is narrow. Donovan had filed the deed transfer within 48 hours of the signing. Every day that passes after a suspicious transaction is a day that recovery becomes harder. Craig Donovan's career did not survive the verdict intact. The public court record, the pattern of prior transactions, the documented arrangements with POA holders, the discovery evidence that his attorneys had fought so hard to suppress became the defining fact of his professional reputation in Harlan County and beyond. Two subsequent development projects he had in early negotiation fell apart after the verdict became known. A formal complaint was filed with the State Real Estate Regulatory Board. As of the time this case entered the public record, that complaint remained under review. He has not completed a land acquisition in the county since. Eleanor's land is still in the family. She continues to lease portions of it to the same neighboring farmers who have worked it for years. The timber sections are maintained. The fencing is in order. The east pasture looks, on a clear October afternoon, exactly the way it has looked for 40 years. She is not bitter about what happened. That is perhaps the most striking thing about Eleanor Marsh, not the sharpness she displayed in that deposition, not the quiet resolve with which she told Susan to do whatever needed to be done, but the absence of bitterness in the aftermath. She got what she wanted. The land stayed in the family. The man who tried to take it learned that she was not, in fact, an easy target. She said something to Gerald Purcell on the day the verdict came through that he later shared, with her permission, when the case was discussed in a legal context. She said, "I always knew the difference between a man who respects you and a man who is waiting for you to make a mistake. Robert knew that difference too. We just never thought we would have to prove it in court." At the beginning of this story, we told you that in 2019, an 84-year-old woman in rural Tennessee lost 300 acres of family land in a single afternoon. She did not lose it to a bank. She did not lose it to unpaid taxes. She lost it to a man who believed that patience, paperwork, and the right signature in the right place could take from her what 40 years of work had built. He was wrong. And the legal tool he used to do it, the power of attorney he had manipulated, the instrument he had turned into a weapon, became, in the end, the clearest evidence of exactly what he had done. Eleanor Marsh walked out of that chapter of her life with her land, her dignity, and the particular satisfaction of a woman who was told she was too old to fight back. She fought back anyway.